Hello and welcome to Talking Law podcast, the podcast where you can hear barristers, judges, solicitors, managing partners and more talk about their careers and lives in the law. I'm Penni MBE. I'm a practicing barrister at Kenworthy's Chambers in Manchester, and I'm the founder of Women in the Law UK. Talking of which, you can now buy tickets to both our annual dinner on the 9th of March and the Women in the Law conference on the 10th of March from womeninthelawuk.com. Both are held in Manchester. This episode is supported by CBRE, the leading global provider of commercial real estate services and investments. Find out more about them at cbre.com. I'm delighted to be talking law with Lord Pannick KC, or David, as he told me to call him. David has been a practicing barrister for 40 years and is also a Crossbench Peer in the House of Lords in the UK. Specialising in public law, human rights and appellate advocacy, he practices from Blackstone Chambers in London, which is where we recorded this interview. He began by telling me about the start of his career, along with his first case.
I started in practice in the law in 1980, and it was a good time to start in public law chambers, administrative law, constitutional law, because judicial review was getting off the ground. Courts were beginning to look at human rights cases. My first case was in 1980. I was the second junior to Anthony Lester QC, and our client was a man in Singapore who had been sentenced to death for drug trafficking. Gosh. And he was appealing to the Judicial Committee of the Privy Council in London. Yes. The final court of appeal from Singapore was in London, and the case was heard by law lords, by senior judges here. And so Anthony Lester argued, I didn't say a word, I just sat there cowering. He argued that it was a breach of this man's constitutional rights to execute him. And we lost. Yes. And our client was hanged. And that's not a good way to start your practice. I always tell people you can only get better after a start like that with your first client hanged. I tell that to clients. And some of them are reassured by that, some not.
Well, let's go back to the beginning then. What drew you to the law? I always ask this question because people have different inspirations, but because you've been in so many cases, how...
Well, I was always interested in the law. I liked arguing. I was debating. I was debated at school. This sounds a bit pathetic, but when I was 16, I used to go to the Old Bailey and watch trials.
Oh, did you? You were one of those.
I was. I'd sit there. I didn't take notes, but I did go to the Old Bailey, and I like the idea of the law. I like the structure that you argue and the other side argues. It's all very civilized normally, and then the judge or the jury decide. And so I was quite clear from an early age, 15 or 16, that's what I wanted to do. Yes. And I got a place at Oxford to read law. I was there for 4 years doing law. And then I started in what was then Two Hare Court, which had been the chambers in the 17th century of Judge Jeffreys. And we changed it to Blackstone Chambers when we moved. And I've been chugging along ever since.
Wow. Well, we may have dealt with it already, but I want to ask you at this juncture about memorable cases. Yeah. And I have several of your memorable cases, but perhaps the public and the one that even practicing barristers were watching in the robing room, you'd been in the middle of a rape case and it was quite a nice escape, was the prorogation case.
Yeah, that was extraordinary because there was so much public interest in that. Yes. I mean, I still get emails from people around the world who comment on that. I mean, it was dramatic in the extreme that Brexit still wasn't done. This was the autumn of 2019. Yeah. We'd had a referendum was it June 2016,
yes.
Parliament was divided, the country was divided. We had a new Prime Minister, Boris Johnson, who was determined, and one understands why, to get this done. But unfortunately, the way in which he decided he was going to get it done was to suspend Parliament.
Yeah.
And I was on a family holiday. I was in Botswana.
Oh, lovely.
Yeah, it was absolutely magnificent. We were on safari in Botswana.
Yes.
And I started to get messages, because the email system was sporadic. I started to get text messages, you need to ring your clock. It's not always a good sign when you're on holiday.
No.
It's the last thing you want to hear. But then I began to realise there was a good reason on this occasion to ring your clock. It was a case you wouldn't want to miss.
Yes.
So I completed my holiday, arrived back at Heathrow Airport on the Monday morning in, I think it was early September 2019. And we were in court, in the divisional court, before the Lord Chief Justice and the Master of the Rolls and the President of the Queen's Bench Division in the Queen on the application of Gina Miller against the Prime Minister. The issue being, was it a breach of law? Was it unlawful for the Prime Minister to advise Her Majesty to suspend Parliament for 6 weeks at a time when Parliament was heavily involved in the negotiations that this country was having with the EU? Yeah. And the Prime Minister clearly thought that Parliament was an inconvenience at this sensitive time, and he didn't want Parliament sitting. And I said to one of the juniors, this is quite an unusual case. In fact, in one of the juniors, it was his first case. And I said to him, you should realise that not every case will be before the Lord Chief Justice, the Master of the Rolls and the President of the Family Division. Yeah. Anyway, we got smashed. They were completely unimpressed. And they said, whether Parliament is prorogued by Her Majesty is not a legal question, it's a political decision. And they threw us out. And we appealed to the Supreme Court, and they were willing to hear it very, very speedily, within 2 or 3 weeks.
Yes.
And we triumphed. We had an astonishing victory where the Supreme Court held that the Prime Minister had acted unlawfully. The effect of his decision was to remove Parliament from playing any role at an enormously important time politically. And that was the unanimous decision, 11 of them.
Yes.
And there's a case in the US Supreme Court where the now Chief Justice, John Roberts, lost a case 11-0 in the US Supreme Court. And he was asked, well, why did you lose 11-0? And his answer was, well, because there are only 11 judges. And it was quite clear. It was quite clear early on in the hearing that we were going to win this. Not necessarily 11-0, but we were going to win. And win we did. It was highly controversial. There was a lot of academic lawyers, a lot of politicians who thought that it was not the business of the court to tell the Prime Minister when to prorogue Parliament. They went even further. They said that the prorogation, the suspension of Parliament, was as if it hadn't happened, that Parliament had not in fact been prorogued, it was always sitting. And I always thought it was a bit like that episode in the television series, you're far too young to remember, Dallas, when Bobby Ewing, they realised Bobby Ewing had been dreaming the whole of the previous series.
Yes, and the whole country was hooked.
Indeed. It was like that Boris Johnson had suspended Parliament, but he hadn't really, because it was null and void. So Parliament came back the next day. Of course, none of it actually mattered, other than to constitutional lawyers, because Boris Johnson managed to persuade other parties to agree to an election. He triumphed, and Brexit was done.
Yes.
I can't remember what happened to him, Boris Johnson. I think he went on to do something or other.
Well,
haven't heard of him since.
Well, we're going to come back to him in a moment.
Okay.
But
so it's a great case.
It was a really great case.
Yeah,
so would you say that was your most memorable case?
Oh, undoubtedly my most memorable case, because it was fascinating legally. It was of enormous political significance at the time. It attracted a worldwide audience, and we won.
Yeah,
all of those characteristics go together. The only thing that it didn't have was a £1 million brief. That would have helped. But,
quite.
But you can't have everything in life.
No.
So I enjoy. It's not the only fascinating case that I've done, but it was the most interesting, I think.
Yeah. Well, maybe can you indulge me before I ask you my next question? Really, what has been the most fascinating case? Is there a case that beats that, apart from the first case you told me about already?
No, I don't think so. I mean, I've done other cases that were very satisfying. I mean, in particular, in 1999 and 2000, I acted for servicemen and women who had been dismissed from the armed forces because they were gay. Not because of anything they'd done, because that was their sexual orientation.
Yes.
And we lost that case in the domestic courts. The domestic courts were very sympathetic, of course, to the claimants, but they said it's not for us to decide a major policy issue. And we went to the European Court of Human Rights in Strasbourg, which said this was a plain and obvious breach of Article 8 of the European Convention on Human Rights, the right to private life.
Yes.
I think there was a dissent. There was a dissent by one judge, and we knew he was going to dissent because during the oral hearing, he asked a question, and his question was, "Well, that's all very well, Mr. Pannick, but what's going to happen if these gay servicemen with their colleagues are on manoeuvres? They're up the top of a mountain. It's very, very cold, and they have to huddle together for warmth. What's going to happen then?"
What?
And
I don't want to be disrespectful.
what
was your response?
My co-counsel Ben Emerson,
yes,
whispered to me, "Tell him that if it was that cold, the last thing they would want to do would be to get their private parts out." And I gave an edited version of that excellent answer to the court. Didn't persuade that judge, but it persuaded the others were laughing. They thought this was really very, very odd, and it was.
Yeah.
So that case was highly memorable, and of course it changed the policy.
Yeah.
The MOD, with the cover of Strasbourg, changed the policy, and as we had argued, there was no difficulty at all in gay service men and women performing the function of being employed by the armed forces and doing their job. But it was tragic for these people because their careers had been destroyed.
Yes, well, I do know one of such people because the civic mayor, former civic mayor, Carl Austin Bin, was one of them.
Oh, was he?
Yes, and he was dismissed, and I think their medals were even taken.
Yeah, it was outrageous. It was completely outrageous.
And not right.
Yeah.
Can I just move on and ask you about advocacy? I teach advocacy to pupils and then you practitioners, and I know you wrote a book called Advocacy.
Yeah, I did.
It was a very long time ago. I don't want to embarrass you, but
but you're about to, aren't you?
Well, it was, and I noticed you can buy it in eBay. You can't really buy it in print, isn't it? I can get a copy. I remember reading it when I was a pupil, so that's at least 23 years ago. But when we watched the prorogation case, and even now, when you have to do the review of students and they do their advocacy, your feedback, we demonstrate, so on. And we all call you the master.
No.
Because you were so composed.
The master was Noel Coward. Noel Coward was known as the master.
Oh,
I shall have to get a silk dressing gown and a long cigarette holder.
Yes. I'll send you one in the post for Women in the Law, saying the master.
The master, my goodness.
But really, the master in advocacy, because I did watch, as did judges, counsel, and then QCs, and now KCs across the country, young people, about advocacy. And yours was, if I may say so, miles ahead of the others. Bearing in mind the Supreme Court, no robes, you're just there as you are, which I suppose is part of, the intellectual capacity of those appearing there. Yeah.
I must say, it is easier to do a good job if the court is with you than if the court is hostile.
Yes.
So I did have that considerable advantage. I think if there's a secret of good, I think there are two fundamental points. The first is preparation. Nobody at all can stand up and argue a case unless they've put in a lot of work. Cicero, who knew a thing or two about advocacy, he said an advocate cannot be eloquent upon a subject that is unknown to him. And I collect examples of mostly appalling advocacy. Other people collect stamps or air miles or sometimes impressionist paintings, if you're lucky. But I collect examples of curious advocacy. I'll give you a couple of examples of bad advocacy. Counsel was asked in 2008 by the United States Court of Appeals, the Fifth Circuit in New Orleans, why he had not addressed in his submissions the relevant judgment of the Supreme Court. He just ignored it. And his answer, he told the court in his oral submissions, Your Honour, I try not to read many cases. That's what you shouldn't do. And there's another one, 2011, Judge Charles Simpson, sitting in Louisville, Kentucky, reprimanded the unfortunate counsel. He told counsel in his judgment, he said, counsel should appreciate that Wikipedia is not an acceptable source of legal authority in the United States District Court. So you've got to prepare. That's the first key principle. The other key principle, and this is counterintuitive, but it's true, advocacy depends as much on listening as it does on talking. Yeah. You have to listen to the judge, you have to listen to your opponent before you can make a valuable contribution. And I think sometimes people don't understand that, but it's of vital importance.
Yes. I feel like we're having a masterclass. There are these things people can subscribe to, how to write a book, how to cook, a masterclass in advocacy, and perhaps you should do one.
Well, perhaps I can have an advert here, because this time last year, it was November 2021, I gave the Hamlin Lectures, which is a series of lectures each year on the law, and my subject was advocacy. Fantastic. And I gave 3 lectures, one on principles of advocacy, one on the morality of advocacy, one on the future of advocacy. And the lectures are being published. They're taking a bit of time, but they're going to be published, I hope, early next year. Fantastic. By Cambridge University Press. So
brilliant. Well, I will share it.
That's an advert.
Yes.
And available in all good bookshops, but not quite yet.
Good. Okay. Well, we'll look out for that. Please. Which will be great. And then can I ask you, before I move on then, about this? When you get a brief, instructions come in. Now they're all, not physical anymore, are they? But they come, or you have to access them, or you're invited to log in as a solicitor or whatever, government department or whatever. And what's the first thing you do when you're reading it? What part of it? Because I asked Joe Sidhu this. It's still on advocacy. Yeah. And on the new practitioners course, we often ask the youngsters this, because of course they've had 3 years to ruin everything you've told them when they start off as pupils. So we try and find out, where they're at and what they do. And I remember certainly in a criminal case, this chap said, well, I look at their previous convictions. And I said, what? Is that the first thing you do?
I think most of my clients will be a bit surprised, exactly. If I'm doing, because most of my cases nowadays are appellate advocacy. It's Court of Appeal.
Yes.
It's the Supreme Court. And if I were to say to the solicitors, can I please have a list of the previous convictions of the client, I think they'd be a bit surprised. I mean, the question's a bit like asking a composer, what comes first? Is it the music or the lyrics? And most of them will tell you, well, it all depends, and they come together. So I don't think, I just read it.
Yes.
I just read it. What I often do, if it's an appellate case, the first thing I'll do is I'll read the judgment from which the appeal is being brought.
Arises.
I mean, that's really important.
Yes.
But the instructions nowadays tend to be very helpful, very focused. I mean, I can remember the day when I was doing cases in the magistrates' court, or more the county court, and the instructions will say, counsel, please read the papers and do his best for the client. That was the sort of instruction.
I think I've seen one or two of those, just.
But they tend nowadays to be a bit more focused and helpful than that.
Yes. Well, can I ask you, because this is a very recent opinion that you gave on a case and an issue, because it's all been publicly reported, so I think listeners are interested. And it's on the former Prime Minister and the constitutional question recently about whether or not he misled Parliament.
Yes.
I'm not interested in, fees or whatever were paid for it. No interest at all. I'm interested in law.
Well, can I just say, there has been a report of a very substantial sum of money being paid. I think it was 130,000.
Yes, I've written it down in my research.
Yeah, well, absolutely. But even if you're not interested, your listeners might be interested to know that certainly wasn't paid to me. It's been misreported, because what it was, as I understand it, is the sum of money paid to my instructing solicitors, who are Peters and Peters, very, very distinguished for white collar crime.
Yes, they are.
Very distinguished. And it was for a number of months' work that they are doing, as I understand it, I have no private knowledge, for the client, Boris Johnson. It no doubt includes disbursements, in particular the fee paid to me and my junior, Jason Pobjoy, also of Blackstone Chambers, who greatly assisted in this work. So I just want to clear that out of the way, in case any of your client, any of your listeners think I'm being paid a fortune. But that was being paid government rates. But on the substance of the matter, yes, Boris Johnson told Parliament, as you know, that there'd be no breach of the coronavirus regulations.
Yes.
There was then a fine imposed, which he paid. Parliament decided that the question of whether he misled Parliament should go to the Privileges Committee.
Yes.
And I was asked by Boris Johnson to advise him on whether the committee have understood correctly the rules relating to contempt of Parliament and the fairness of the procedure. And Jason Pobjoy and I wrote an opinion. It was why the Prime Minister then put it on gov.uk so people could read it.
Yes.
People will form their own views. Again, highly contentious. A lot of people. Well, what's happened is that those who think that Boris Johnson is a martyr and should never have been removed think I'm a hero.
Yes.
The Daily Mail have repeatedly described me as top QC.
I know, I've seen it.
And
in the research for this interview.
Yeah, you're only top QC if there's two circumstances in which you're top QC. The first is when they think your advice is very good. The second is if you're in the Daily Mail because of some sex scandal, then you're top QC or top judge. There's never less than top judge accused of sexual harassment. They don't have that. So I'm a hero to them. Those who are opposed to Boris Johnson think he ought to be booted out of public life, think it's an outrage and that I'm a disgrace. I've had a number of emails from people telling me I should resign. Not sure from what, but telling me I should resign. And people will form their own view on the strengths or otherwise of the opinion. But what I can tell you is that it is my view. I mean, what I do is I advise people, I represent them in courts, And it really doesn't matter whether they're Boris Johnson or they're an asylum seeker.
Yes.
They get my view. And that's what they pay me for. Sometimes a lot, sometimes not very much. Boris Johnson is no different from any other client. And my advice, sometimes the courts agree, sometimes they don't. The problem, of course, with the parliamentary committee is they're not subject to judicial review.
Yes.
You know, they make it up. They decide. And there's no independent body that marks their homework. It's very, very unfortunate, I think. But that's the law.
Yes.
That is the law of the land. They will eventually make a recommendation to Parliament. Parliament will decide what happens in this matter.
Yeah, it really interesting. I must say, you're sitting in sort of quite a modest grey jumper and shirt, not dripping in gold. So I don't know.
No.
I don't know.
Oh, I'd like to. I'm sorry, you say. I'd like to think that I'm dressed in a smart, casual.
Well,
manner.
you are, but
I'm going to have to improve. I'm going to go off to Selfridges as soon as we finish this.
Well, I just mean that there's no sign of £130,000 that's suggested.
No, I'm not wearing a £130,000 suit.
No. So I wanted to clear that up.
Thank you.
As well. I wonder if we could sort of ask you some other questions about family life. You've got, I think, 5 children.
No, I've got 6 children.
6 children.
Yeah, the 6 of them would be very sad. No, I was married for many happy years to Denise, who sadly died of breast cancer in 1999, and we had 3 wonderful children. And then in 2003, I was very fortunate. I'd met Natalie, and we got married. And I've had many happy years so far with Natalie, and we have 3 children. So we have 6 children. Wonderful. 3 boys, 3 girls.
Wow.
So I'm very fortunate, very fortunate.
And can I ask you about well-being? I always ask this, with a large family, fortunately. How do you juggle well-being, wellness? Because I have to say, this job is not conducive to...
No, it's very stressful.
Yeah.
It's enormously stressful. And I think if you don't feel that stress, well, then there's probably something wrong with you, because any normal person would find it stressful. And if you look back over history, you can find any number of examples of very distinguished barristers who found it stressful throughout their career. I mean, in his autobiography, John Mortimer, QC, wrote that he still had regularly recurring dreams, in which he'd be running through the Royal Courts of Justice, desperate to get to a courtroom where he had no idea what the case was about and couldn't find his brief. That's an extreme example. But yes, we all feel that. I think it's very important to have a personal life. Yes. If you're fortunate enough to have a family, that helps. If you're not, you need good friends. And you have to have other interests. Yeah,
so I was going to ask you, what are yours? If you've got hobbies.
I'm not sure about hobbies, but I'm a season ticket holder at Arsenal Football Club, which creates stresses of its own, but different sorts of stresses. I love musicals. I regularly take my family, and when they don't want to go, I take Natalie, if the children don't want to go, to see musicals, go to the theatre.
Wonderful.
A lot. Foreign travel, I love. Just back from Rome, speaking last weekend to the American College of Trial Lawyers. That was a wonderful weekend. Yeah. So you have to do other things. And as I say, I mean, I got to the stage when I was in my 50s where I needed to do something else than argue cases. I love arguing cases, but it's not really a serious job, is it? I mean, it's
It is.
You're not making decisions. That's what I mean. You're presenting one side of the case. And most people, when they get to that age, need to do something else. So you apply for the bench. Quite a lot of people.
Yes.
Whether it's High Court, Circuit, magistrates, tribunals, whatever. That's what people do. But I didn't really want to do that. I didn't think I have the patience to sit in judgment on others listen. So I was very pleased to get my appointment as a crossbencher in the House of Lords, and that provides me with another interest and some relaxation, and involvement at a very minor level in the political world. So I love that.
So just explain, because we have a global listeners to this podcast. What does the sort of average day involve? Because I have interviewed, I should say, Dame Tanny Gray-Thompson, who is a friend of mine, the Paralympian.
Yes, and I know well, yes.
Well, right. Well, I've been there to observe proceedings on a number of occasions. So how does it work? And might I say, and how do you manage that with the day-to-day?
Well, there's no normal day. I spend more time in the House of Lords when I'm spending less time at the bar.
Yeah.
So if I have a case, I won't be going to, if I have a 5-day case, I won't go to the House of Lords that week. Okay. If I'm only doing advisory work, then I go to the House of Lords, sometimes just for question time, maybe to discuss matters with people, forthcoming legislation. But if there's a bill that excites my interest, then I will devote a lot of time. I'll go to the committee stage, I'll go to the report stage, speak at second reading. I'll have meetings with other peers where we discuss putting down amendments, meetings with ministers to discuss those amendments. And it can be very time consuming, but very satisfying. And the House of Lords is a remarkable institution. I mean, I had no idea until I joined that legislation, when it is proposed, normally starts in the House of Commons, not always, but the House of Commons has no time or inclination to look at the detail of the legislation. The House of Commons tends to focus on the big policy issues. There's some attention to detail, but not that much. And when it comes to the House of Lords, we go through it at committee stage and report stage, line by line. Wow. And any peer can table amendments which are all debated. There's no time, there's no cut-off. We can debate the amendments, and we do, and everybody can speak. And we make improvements to the legislation, and a remarkably high proportion, more than 90% of these amendments are not contentious. They're accepted by the government and they improve the legislation. Yes. Sometimes we poke our noses into big policy issues and there's a row, and then it goes backwards and forwards between the Lords and the Commons, what we quaintly call ping pong. Yeah. And normally we give way, and rightly so. Almost always we give way, because they're elected and we're not.
Yeah.
And that's right and proper. So we are a constitutional anomaly. We're part of the legislature. We make the law, but we're not elected. But we perform, I think, a very important role of revising legislative proposals, improving it.
Yes.
And if you had an elected house, well, you'd have two problems. The first problem is an elected upper chamber would not give way to an elected House of Commons so easily. You'd have two elected houses. And the second problem is that the House of Lords contains a very large number of people, like Tanny Gray-Thompson, who are experts in their field.
Yes.
And you simply wouldn't get such people there if you had an elected house.
Yeah.
So we're an anomaly. But it's quite difficult to think of a better solution to the problems that the House of Lords helps to solve.
Yeah.
So I enjoy it, and I think we play a valuable role.
Well, I have to say I agree, particularly on issues like the right to protest and the online bill, variety of other bills.
What we were going to be, we were all gearing up to deal with Dominic Raab's abolition of the Human Rights Act bill.
Yes,
I was getting what it was called.
Yes,
we were all getting very excited. We were working out which bits, if any, deserved to remain, which bits we wanted to amend. And but he's gone. He was sacked.
Well, he was sacked, but now we've got a new Attorney General, or a new minister who's still very keen in Suella Braverman.
Well, she's now the Home Secretary. She's made public statements about whether we should continue to be part of the European Convention on Human Rights System, yes. Council of Europe. We shall see what comes forward from this government. I mean, the Human Rights Act is very important. It's played a great role, and I think a valuable role in public life, but it's not perfect. And the government may wish to bring forward proposals for improvement, and they will be debated. But the Dominic Raab's bill was just a root and branch attack
yes.
on the Human Rights Act, and would have been, I thought, a very unfortunate development. And I'm very pleased that it's gone away.
Yes, well, so am I. Now, I want to ask you some quick fire questions, which we wouldn't do in court.
Okay.
One of them is...
well, I'll tell you what ministers say in the House of Lords when they get questions like that. They say, I will write to the noble Lord. Can I do that?
No, because these are fun.
Okay, all right.
Such as... firstly, I'll say them all so you can think about them.
Right.
What's your favourite book and why?
Yeah.
And then if you've got a favourite fictional legal character, because of course, I love Rumpole, and the books were of course written by John Mortimer. But I wondered if you had your own favourite fictional legal character. It might be Atticus Finch, I don't know.
No.
Or whoever. So if you could share that with me. And then if someone was going to play you in a kind of biography of your life, who might it be? And I don't give many interviews actually, but I was asked this once, and I said the American actress Viola Davis.
Oh yeah.
But she's American, and the actress needs to be English, really. And I'm
no,
not sure.
She's an actress. She can play someone of a different nationality. I don't believe in this idea that you've got to, you only play someone who's got the same characteristics as you. But I understand.
I know. So now I would say, if it was me, Sophia Kernanda, the British actress, maybe. I don't know. No one would be interested in anything about my life. So that's the end of the quick fire question. I'll come back to my substantial last few questions in a minute. But,
all right, book.
Yeah.
Well, I suppose Proust. I love Proust. I've read Proust maybe 3 times, and it's so long in number of words, number of pages. It's so complex. It's got so many themes to it: comedy, tragedy, drama. But I think that's probably my favourite.
Yeah.
Probably.
Okay.
The other one, I mean, that's fiction. Non-fiction, I think Robert Caro's Life Not Yet Completed of Lyndon B. Johnson. That is a quite magnificent work, quite magnificent to portray not just the life, but the exercise of power in the Senate. And I hope he has many years left to complete the work. I think he's up to about 1965, and he's got a few more years to go, in particular the end of Johnson's presidency. So that's probably my choice.
Good. And I can't remember the questions now.
Well, the second one was the fictional legal character, was it?
Yeah.
Yeah. Well, Mr. Chaffanbrass, Anthony Trollope's lawyer in The Three Clerks. Let me give you a quotation. Mr. Chaffanbrass's business is to perplex a witness and bamboozle a jury. And it raises really profound questions about the morality of advocacy. But that's what he does. He just is a completely amoral advocate who performs the task of acting on behalf of his client, whoever they may be. And I think he's a fascinating character. So that's my answer to that one.
Brilliant. And then what about an actor?
Well, as I get older, the late Walter Matthau is no longer available. Might have done a good me. Some people have suggested to me, perhaps slightly unkindly, that Danny DeVito would be a good David Pannick.
Oh, no.
I'd like to think a younger Robert De Niro, maybe, or Al Pacino might be good.
Yes.
I once saw Al Pacino on stage.
Did you?
I think in New York as Shylock in The Merchant of Venice. Did a pretty good job. So one of those perhaps.
Yes.
Would do. They do a very good job, I'm sure, of any character. But I would be very happy to be portrayed by either of them.
Fantastic. And tell me, do you ever get nervous? I know we sort of touched on this before, but adrenaline, we touched on it because I was talking about you being so cool, calm and composed, even when you refer to a file. And I think it was as an associate from Mishcons came forward with the folder and you stopped, got the file, carried on.
Yeah, that was very embarrassing. That was in the prorogation case.
It was. And I remember it well because Lady Hale kind of highlighted it a bit by pointing out that all the counsel were men. And this young woman was sort of on the pulse because you paused for a moment and she brought it. I didn't think anything of it. Yeah. But I just wondered if you ever, I get nervous about the Court of Appeal, especially, not doing jury trials.
Well, you're nervous because you just don't know what's going to happen. I mean, that was a very good example. There's a famous case in the United States Supreme Court where the advocate can't find the reference he's looking for in his papers. He's through his papers. And Justice Scalia, there was a long pause, and Justice Scalia broke the silence. He said, when you find it, just shout bingo. How humiliating, really humiliating. And every advocate's worried that events like that are going to happen.
Yes.
But if you prepare, then the chances of that are reduced. They're not removed entirely, because you can never be sure what's going to happen in court. And that does make you nervous, does make me nervous. But the other side of that is the excitement, the fun, the exhilaration, the fact you just don't know what's going to happen in court. If I'm doing a case, you can have a guess at what the court's reaction is going to be, but you're never sure. At least I'm never sure what the court's going to say. Yeah, sometimes more in some cases than others, but I am constantly surprised by what happens in court.
It's very good to know, because I want to ask you about social media.
Yeah, well, I don't touch social media.
I know.
I'm not on Twitter. I'm not on Facebook. And there are two reasons for that. First, I don't have the time.
Yeah.
And secondly, I'm a sensitive soul. And I really can do without the aggravation. I sometimes write newspaper articles, and I've made the mistake of scrolling down on the website.
Comments, yes.
And you look at what people have said, and it's so dispiriting. The venom. I know. The venom is appalling. That's what I like about advocacy. That normally the arguments in court, and I think it's the great credit of the legal system. It's a wonderful thing that you're having these highly contentious issues being debated and decided.
Yes.
And they're debated and they're decided after argument which is presented in, normally, not always, in a calm, rational manner, a polite manner, on each side. And I think that's a wonderful thing. And you compare it with political discourse nowadays, which is getting worse and worse, and with Twitter discourse, which certainly does not have those attributes. It is a matter of shouting at each other, over each other.
Yes. And
I think that's very, very unfortunate. So I'm very keen on advocacy in the sense that disputes are resolved by reasoned argument. Maybe an ideal, but it's an important ideal.
Well, it is, and I have to tell you, David, see, I've built up the courage after about an hour to say that. When
we're now old friends, aren't we? We're now old friends.
We are. Yeah. I'm going to send you pictures of the dog or flowers, which is what I normally put on Twitter. But when I was a pupil 23 years ago, one of the things we were asked to do is to cut out cases, and I say this when I talk to schools, and children and undergraduates don't believe you. You cut out the reported cases and you put it into Chambers folder so that others, SILs, could read them. And I think now there's probably an app which does it for you. I don't know. And you had a column in the Times.
I did.
For such a long time that we all got used to your face and what you wrote. And it was always quite nice that you writing commentary, whether it was on cases or a variety of things. And of course, there was no opportunity to comment on that.
No, in those days, no.
I mean, now, of course, there are.
It was a matter of take it or leave it.
Yes.
Now everybody can publish their views. Everybody is a commentator.
Yes, exactly.
And that's a good thing, but it's also a bad thing when people abuse that with aggressive comments.
I agree. Well, can I ask you about diversity? I am a short black woman. And
I'm a short white man, yes, indeed. We all have our characteristics.
Of course. We can both punch, you more than me, above our weight. But I wondered what you thought about diversity in our profession, not just the protected characteristics, but how are we doing any better in law? We're
doing better than we were.
Yeah.
I mean, when I started out, as I said, 1980, I was a pupil in 1979. My late wife, Denise, was also a trainee barrister.
Yes, I saw
and
that.
I remember very well that she told me that there were chambers to which she had applied who told her, well, you're very good, but we can't take you because we don't have any women's laboratories. Now, that is astonishing. It's not, the 19th century. This is 1979. We're talking less than 50 years ago.
Yeah.
And it's shocking,
yes.
And it's shameful. And the number of black faces in the bar was very, very few. So I think we have undoubtedly made progress, and rightly so.
Yes.
But there's an awfully long way to go. I mean, I think it's very, very regrettable, although I understand why, that there are so few faces other than white faces in the appellate courts.
Yes.
And that is despite genuine, good faith, enormous efforts made by the Judicial Appointments Commission, by the judiciary, by the senior members of the bar to try to improve all of this. And we've got a lot of work still to do because I'm sure you think, it is absolutely vital if you're going to ensure public confidence in the legal system, that the people who are administering justice look like the people that they are administering it for.
Absolutely.
And that is vital to public confidence. I think also, and Brenda Hale has made this point, it's also vital for the quality of justice. It's not only how it looks, but it's vital for the quality of justice that you have diversity, not just of faces, but of attitudes and experience.
Absolutely.
And opinions.
Yes, and of thought.
And of thought.
Yes.
So it's all crucial. If you ask me how we're going to do it, I'm afraid I've got less of an answer because people who are far more knowledgeable than me have spent much of their lives trying to achieve this. I am particularly worried by the current difficulties, problems in the criminal bar.
Yes, where I am.
I sympathise, and you're doing vital work, but the low rates of pay will have, and the tensions and the pressures will inevitably have a disparate adverse effect on people from less affluent backgrounds.
Yes.
And the bar has, I think, made huge efforts in the last 30 years to ensure diversity of those coming into the criminal bar. And that is vital for the reasons I've given, because you and your colleagues are going to be the criminal judges in the next 10, 20, 30 years. And if there's no diversity at the bar, the problems, and the real problems of diversity on the bench, are not going to be alleviated.
No. And I can tell you, every week, somebody leaves. I get text messages. I got one this morning traveling down of a woman who was leaving. It's really sad because we will then not have the quality either. Yeah. Very able and talented people leaving, not just women. But it's something that upsets me and I'm passionate about. But let's get back to something a bit more positive.
Yeah, that's a bit depressing, isn't it?
It is very depressing.
Yeah, but I hope. I mean, there are many demands on public expenditure, but justice really has to be at the top of the tree. And I hope that the new Lord Chancellor will take a more active approach in trying to resolve these problems than his predecessor, Dominic Raab, who, as I understand it, wasn't even prepared to meet the Criminal Bar Association leaders.
No, wouldn't engage in any conversation. So yes, there's a positive. I think we're looking more positive. Can I ask you, David, what's next? You don't want to go on the bench. You've written lots of books.
Well, I'm too old now. I'm 66. Although they've just increased the retiring
to
age.
75.
Yeah, so I've got another potential 9 years. But I enjoy what I do. I enjoy it enormously. Not just the advocacy, but I enjoy the independence.
Yes.
And I'm not keen at all to give up independence. I think those who do the job of judges are enormously impressive. I think we have a quality of judiciary that is quite astonishingly good. And those who do that work do enormously valuable and important work. It's just not for me.
Well, Lord Reid, I think, said he wanted to see more diversity in the Supreme Court itself, which has gone a bit backwards in my view, but my view doesn't count for anything because there's still only got one woman in Lady Rose. And so, he wants to see some more diversity, if I can put it that way, before he retires. So I was thinking, with 9 years left before the retirement wage, whether that might come back to you or whether you're content.
Well, I wouldn't improve their diversity, would I? I mean, I'm afraid that I might put myself forward on the basis I've got other qualities, but that isn't one of them.
No,
unfortunately.
So what would you like to continue? Would you like to continue? Well, I asked the question, what's next? Because I just wondered if you're content being an advocate.
Yeah, I love it. Yeah,
books.
Absolutely. I'm content doing all of that. Participating in the House of Lords, although it's quite possible that proposals will come forward to change the House of Lords, make it into either an elected body or a body that represents different regions of the United Kingdom. And so that may be taken away from me. I may be removed kicking and screaming from the Palace of Westminster. And I would be very upset if that were to happen. But otherwise, no, I shall carry on. There will come a point, I'm sure, where my colleagues in Blackstone Chambers will knock on my door and they'll say, David, it's probably time, isn't it? Probably time. It's always said, isn't it? I think it's of the Conservative Party leaders that there's a delegation of the men in suits who come to tell the Prime Minister that he or she really has to go, although that didn't work really with Boris Johnson.
No.
And there's something similar, I think, at the bar. I mean, I've done cases against people who've gone on a very, very long time.
Really?
And have still remained at peak of their powers. I did a case in the Supreme Court. When was it? A few years ago now, probably about 8-9 years ago. And one of my opponents was Sir Sidney Kentridge. And Sir Sidney Kentridge was appearing in the Supreme Court. He was representing, I think, the Law Society. And it was the day of his 90th birthday. It was his last case. And he still knew how to do it.
Really?
Yeah, he was quite extraordinary. So I was for the appellant. And I stood up and I mentioned to the justices what they already knew. It was Sir Sidney's birthday and wished to pay tribute to him. He was a hero, a model for all barristers here and abroad. And then I added, this is all without prejudice to my later submissions, that his case is absolutely hopeless. And I got a laugh. I did get a laugh.
Absolutely.
But the last laugh was on me because he won. But he was still doing it at the age of 90. I don't think I'm going to be still arguing cases at the age of 90. There comes a point where I shall retire gracefully.
Yes.
And just concentrate on supporting Arsenal, reading Proust, and going to musicals.
Well, that's a perfect lie. I mean, I'm a very keen theatre goer myself, so it sounds perfect. But of course, we are now entering a new age. Her Majesty has passed, and we now have a new king.
We do.
And do you see any changes coming in under the new king?
I'm doubtful that we'll see changes. I think if he's wise and well advised, and he's both, he will ensure that he plays as little political role as possible. That was the secret of Her Majesty's enormous success over 70 years, that she played very, very little part in active politics, in fact, none at all. And she said virtually nothing over 70 years that provoked controversy.
Yes.
And that's the way you do it. I think it's the only way you can do it as a monarch in a modern democracy. She, of course, to come back to the prorogation case, she was heavily involved in that because she received the advice from Boris Johnson. But we made it very clear in the proceedings, as was the case, that these proceedings were no criticism whatsoever of Her Majesty. She'd been advised, and Her Majesty takes the advice of her Prime Minister.
Yes.
It's just rank bad advice.
Well, if only they'd asked you beforehand.
Yeah, well.
It will be another story. Well, Lord Pannick, we're coming to the end. I want to ask you about young people coming to the bar now. You've been in a profession that you've excelled at wonderfully. Many of us, you might call them more senior and junior, admire your work and admire actually your cleverness, if I may say so. But have you got any tips for young people who might want to come to the bar now? Looking back, maybe, I don't know, the 21-year-old David, who wasn't Lord Pannick, he wasn't Baron Pannick, it was just David.
Well, I've been very fortunate. I've had great mentors, Anthony Lester, Michael Beloff in particular. Michael was my pupil master. I learnt an enormous amount from both of them, watching them, listening to them, being brought into cases. I've had great opportunities, and I've thoroughly enjoyed it. And so my advice to young people who are considering going to the bar is do it. I can't think of a career that will give you more excitement and interest, and every day is different, as you know, Sammy. I mean, every day is different, every case is different, and the variety of work, the stimulation that it gives is far, far better. I mean, the problem for young people is that if they want to go to the bar, they also know that if they're very clever, very successful in university, they can earn an enormous amount of money from solicitors.
Yes.
And they can sign up and they can be one of the top solicitors firms, and from day one, they're earning a fortune. The bar is more risky, obviously so, but the rewards are great if you persist and if you are successful. And of course, once you start at the bar, they are your cases. If it's a case, you're doing a case in the employment tribunal, the immigration tribunals. It's your case. You ask the questions. You talk to the client. You decide the strategy, and that's an enormous responsibility. But it's also enormously satisfying, and far, far better, I tell people, than earning a fortune at the solicitor's firm. Being involved in a discovery exercise where you're sitting behind the desk going through 50 or 100 boxes, or going through the computer file to find documents that are relevant to the case that your firm is acting in. So go to the bar. Lord Bingham once said, that's where the magic is. And I think he's right.
Fantastic. I mean, what about when failure comes or imposter syndrome creeps in on that journey? How do they get over that?
Well, you have to deal with that. You will lose as many cases as you win, whoever you are.
Yes.
I lose a lot of cases. Everybody loses a lot of cases. But this is true of many professions. I mean, if you want to go into acting, you've got to get used to the rejection when you go for auditions. You might be rejected 99 times out of 100. So you've got to persist. At the bar, you wouldn't be doing very well if you lost 99 cases out of 100, but you lose a lot.
Yeah.
And there's nothing more satisfying than winning a case, but there's nothing more dispiriting, and I've had this experience many, many times, of going back to the clerk's room and they ask you, how did it go?
Yes.
And you have to say, well, the judge decided my application for judicial review raised no properly arguable points and the application was dismissed. I mean, that's dispiriting, but you deal with it.
Yeah.
And, you're just the advocate. It's not, you mustn't get too personally involved. That's also very, very important. You do your job in a professional way. You argue the case. I'm a great believer in the cab rank principle. You argue the case for anyone. There's a famous story. It was in the Times obituary of a great barrister, Michael Lavery QC, who died a few years ago. And he was in the courts, and I think in Northern Ireland, and he was arguing a point. And the judge said to him, but Mr. Lavery, you were here yesterday, and you argued the exact opposite point. And Michael Lavery said, I am a mere taxicab, my lord. And the judge said to him, Mr. Lavery, more a limousine, more a limousine. Great story.
Absolutely fantastic story. Well, Lord Pannick, thank you so much for talking law with me about your career and your journey. It's been an absolute pleasure to meet you. Thank you so much for giving up your time.
Well, thank you, Sally. It's been great fun. Very enjoyable. Thank you for indulging me.
Thanks to Lord Pannick for telling me all about his career and life in law. Thanks again to CBRE for supporting this episode. Do visit cbre.com to learn more about their work in commercial real estate services and investments. I'm pleased to let you know that Women in the Law UK will be hosting 2 events in line with International Women's Day in March this year. You can join us for our International Women's Day dinner on the 9th of March, or join us for our annual conference to be held at Irwin Mitchell. This year, you can learn about how to advance and expand your career in law with guest speakers who will be sharing their wisdom on subjects like leadership, communication, and imposter syndrome. Both events are great events, a fantastic way to meet people and network, and we'd love to see you there. You can now purchase your tickets online at womeninthelawuk.com. If you'd like to support Talking Law, then do get in touch. You can follow me on Twitter at SallyPenny1 and on Instagram, SJSallyPenny, and of course on LinkedIn at Penni MBE. There are plenty of episodes of Talking Law for you to catch up on, and do listen to guests such as activist Gina Miller, Cherie Booth, and of course Lady Hale. Thank you so much to our production team at Purposeful Podcasts. I'm Penni MBE. Bye for now.